This is Earl White, real estate attorney. This is a video about important considerations for everyone working selling property in the state, whether you're the heir, the executor, or a realtor assisting with the sale. You should be aware of these pitfalls and concerns that should be addressed to prevent deal being canceled and falling through, or just wasting your time. I've completed over 100 estate sales on the buyer and seller side, so I can tell you from personal experience, these 5 considerations will save time and heartache for anyone working on these transactions. The first legal consideration when selling property in an estate, which sounds elementary, is to make sure the probate administration for the estate has been completed before signing any listing agreements or listing the property for sale. Oftentimes, realtors, owners, heirs do not realize that just because you're named in a will or the family has reached an agreement for treatment of the property, that just because that has happened does not mean you have the right to sell the property. You must first apply, if there's a will, submit it. If there's no will, then you submit other documentation to the surrogate's court to have a person named either executor if there's a will, administrator if there's no will. Once that person has been named, now they can go forward and sign the listing agreement, sign the contract. A lot of times it will just make it to the attorneys. Nobody picked up on this or thought about it, and it results in the deal falling out in attorney review. Or if the parties can't come to an agreement, it will result in the closing being delayed for months while you're preparing and submitting paper to the surrogate court and then waiting for the court to issue the letters of administration or letters testamentary if there's a will, because they operate at their own time and they really have no consideration for closing dates or contracts of real estate sales. The second key legal consideration in selling property in an estate is to take time and read the will and also examine the family tree, who are the heirs entitled to the property. This is very important. The will oftentimes will define what is supposed to happen with the specific property in the estate, and other times it leaves it open for the executor or administrator to decide the treatment of the property. If the will designates that certain individuals are entitled to direct ownership, they're a direct devisee of the real estate, that person is going to have to sign off on the closing. Therefore, the administrator just can't sell the property, collect funds, and move on. No, prior to closing of title, prior to the sale concluding, all people entitled to a portion of that property under the will need to sign. So if there's a disagreement among the parties that are entitled to it, it could sink the sale or delay it or sink the sale entirely. People don't always realize that. They think, I'm just the executor, I can do as I please and distribute the money. No, that is not how it works. You have to clear title, and anyone that's a direct devisee of the property has to sign on to closing. To that end, what if there's no will and there's no direct devisees? Now, the executor can sell the property and distribute the assets among the estate, but you need to examine who the heirs are, because what can find out if you haven't considered the proper heirs and who's entitled to a portion of the real estate and the estate, there can be surprises that are against the wishes of the family. For example, estranged spouses. If a person was deceased and they were still married, the spouse might not even be in the country for 10 years. That is a major problem because they're going to be entitled to a portion of the estate, and which could be tens, if not $100,000. They were completely disconnected from the property. You have to examine the family tree, look at the heirs, examine the will, so you're not surprised during the sale process or at the closing regarding who has to sign off on the closing documents and how the proceeds earned from the sale need to be distributed. A third legal consideration when you are selling property in an estate is to conduct a title search. What is a title search? A title search is going to pull up county records to look for any liens on the property, such as lis pendens, which is notices of lawsuits, open mortgages, tax liens, so anything recorded in the county records, and then also to conduct name searches for lawsuit judgments on the prior owners of the property. So you have the estate formed and who were the prior owners. Now, just because you're the executor administrators, you may believe that the person that passed away had a current on their bills and didn't have any lawsuits or any undischarged mortgages. Maybe you haven't seen bills, but that wasn't you, and you do not have firsthand knowledge of what was happening prior to that. For people who were elderly and they passed away, the truth is there were outstanding medical bills. There could be judgments related to them. And since they were elderly, there could be scams or people were preying on the situation. Cost to run title search, you're talking about a few $100. So you're not going to break the bank on it. Have the title search run before going down the road of listing the property. Make sure it's clean so when the time comes to sell, you're not going to get shocked with any unexpected liens, any unanticipated recorded documents, any undischarged mortgages. You're going to have the full picture of the title. Therefore, it will be a breeze to clear the title once you have this all wrapped up in advance. The fourth legal consideration when you are completing an estate sale is to be realistic about the condition of the property and the type of buyer that you require for closing the sale. The reality is that property and estate sales oftentimes is not in good condition and needs a lot of work, renovations, and things may not be code compliant. That is because the owners were elderly. They may not have had a lot of excess funds or just the time and energy. If that is the case here, then you will need a specific type of buyer. Depending on the severity of the condition, you may need a contractor or a fix and flip person. If it's going to require a lot of work to get up to code, then you may need a specific type of buyer that will particularly handle. Even New Jersey, where I am, we often have a certificate of occupancy inspection from the municipality where they'll come out, inspect, and give a punch list of items that must be conducted before a formal occupancy of the property. The buyer, if you have a sophisticated fix and flip contractor buyer, they can even handle that pre-closing, or if you can get approval after closing. If the pro, where you can find someone who does need a lot of work, you can find maybe a first-time home buyer or someone else not afraid to put in sweat equity into the property. So be realistic on what's the type of buyer you need, what is the condition of the property, make sure your contracts state there as is, limited inspections, and set the anticipation for you and the buyer and whoever else is working on the sale up front as to what this property is going to need to get sold. And based on that, who is the buyer and what the contract terms need to be can then reverse engineer. The final legal consideration we'll be covering when selling property in an estate is to focus on the tax implications of the sale. You can run basic numbers on what you're anticipating to net from the sale. So you have the purchase price minus the realtor commission minus other standard closing costs. Take that number and present it to your accountant. If you have a tax attorney, to your tax attorney friend, or whoever it's going to be assessing your taxes, present it to them and have them explain to you what are the taxes that are going to be owed on the property. So that becomes very important, one, for your own financial planning. And then two, if you get to the real estate, and for the real estate side, if you get to the real estate closing and say there are taxes due because of the nature of the heirs that are getting the funds, the title company at the closing will oftentimes withhold the money that has to go to the heirs, because they're not going to just give it to the estate because they know taxes are going to be due and who's going to pay the taxes, because it will become a lien on the property if the taxes aren't paid. The title company, to ensure that there are no liens in the future, to clear the title, they'll oftentimes hold an escrow, hold money back until the government tax numbers have been finalized, and then they'll release the escrow. And that can be, if you have a lot of net sale proceeds and it's a distant relation, there can be a lot of estate taxes on the sale. Where I am in New Jersey, if it's a spouse that passes away and the inheritance goes to their spouse or to their children, there are no estate taxes in that situation. But if we're going to further down the line, such as cousins and siblings, then there could potentially be estate taxes due. So you want to get ahead of this issue, figure out what the tax obligations are going to be, because it's either going to come up prior to the closing as part of clearing title, or you come to file your normal taxes with the estate, and then you can know what you're going to be in for and plan accordingly.